Well, good morning. Welcome to the Marshall, Parker, and Weber Elder Law Update for 2020. It's coming to you live via Zoom in this very strange time. I'm attorney Matt Parker, and we're honored to have you attend this very special presentation of the update. If you were not aware, 2020 is the 40th anniversary of Marshall, Parker, and Weber. The patriarch of the firm, Jeff Marshall, founded the firm back in 1980. And here is a photo of Jeff's very first business card. When he started the firm, he decided to open an office in the small town of Jersey Shore, Pennsylvania. And the office was a really small rental space located on North Broad Street in a building that's the former location of the Jersey Shore Herald. It's a newspaper that was famous for once employing an author called Hunter S. Thompson. He wrote the very famous book, Fear and Loathing in Las Vegas. Several years later, Jeff would relocate across the street to 303 Allegheny, which became the firm's principal location for over 30 years. At the time he started out, Jeff didn't have any staff. His first hire was his longtime paralegal and eventually office manager, Gloria Kizis. His early days at the office were spent working on real estate closings, and eventually he was the solicitor for the Jersey Shore Hospital. Now back then, the estate planning world was particularly concerned about the federal estate tax, where the exemption amount from the tax was only $161,000, and the maximum tax rate was 70%. Obviously that hit a lot of people very hard, so he had a lot of home visits to talk with families about the tax and how to minimize its impact. Home computers would not be a part of his practice for a number of years. The technology in 1980 consisted of an electronic typewriter with some word processing software. He had a photocopier and a day timer. That's a wallet-sized personal calendar where you would handwrite your schedule. There were no cell phones, no email, or Zooming. Phones and the U.S. mail were how he communicated with his clients. Elder law was not yet a legal practice in 1980. Very few attorneys did Medicaid applications. He started to learn about that untapped need for our seniors and how lawyers can help older adults navigate that rather complicated program. He spent hours studying, attending PBI events, and soon he became one of those pioneers in the practice we now know as elder law. So to celebrate the last 40 years of Marshall, Parker, and Weber's existence, I will include a few slides that will take us back to 1980, which seems like a lot simpler time than the world we find ourselves in today. First, let's start out talking about the most significant legislation of last year that affects both estate and retirement planning, and that is the Secure Act. The Secure Act stands for Setting Every Community Up for Retirement Enhancement. The act became effective January 1 of this year. It has a lot of provisions intended to help more people save for retirement via tax-friendly retirement accounts. For years, the data has indicated that most Americans are not saving enough for retirement. Most workers need to supplement their Social Security with personal savings. According to the data from the U.S. Bureau of Labor Statistics, only 55% of the adult population even participate in a workplace retirement plan. And even those who do are often very much behind when it comes to investing part of their paycheck in retirement accounts. Now, the Secure Act aims to encourage employers who have previously shied away from these plans to start offering them. The Secure Act tweaks a number of rules related to tax-advantaged retirement accounts. Here's a simplified overview of what it's going to do. First, it's going to make it a lot easier for small businesses to set up 401k plans. There's a maximum tax credit of $500 per year to employers to create such a plan. It enables businesses to sign up part-time employees. There's also a pushback of the age at which retirement plan participants need to take their required minimum distributions. And that age has been pushed back from 70.5 to 72. You can now use tax-advantaged 529 accounts for qualified student loan payments. Previously, these 529 plans were strictly for paying K through 12 expenses. But now these tax qualified savings funds can be used to pay off college debt. There's a penalty-free withdrawal of $5,000 from 401k accounts to defray the costs of having or adopting a child. Now, the withdrawal must be made within 1 year of the qualifying event. Now, if there are two parents who both have retirement plans, they can each withdraw $5,000. The Act also encourages employers to include more annuities in 401k plans. Now, for estate planning purposes, the Secure Act also includes a change that will affect most non-spouse beneficiaries who inherit an IRA or other retirement plan at the death of the account owner. The change affects what is commonly known as the ability to stretch the retirement account distributions over time. Under the old pre-Secure Act law, the designated beneficiaries who inherited an IRA were permitted to spread out their withdrawals from the account over their life expectancies. For younger beneficiaries, withdrawals could be deferred for 30, maybe even 40 years. During this time, the accounts could grow on a tax-deferred basis with only the required minimum distribution being taxed. This was referred to as stretching the IRA. Now, under the Secure Act, most non-spouse beneficiaries will be required to withdraw all of the money in the inherited account within 10 years of the death of the account owner. Now, that can create a major income tax problem for beneficiaries of larger accounts. Now, there are exceptions to this 10-year rule. If the beneficiary is an eligible designated beneficiary, they will not have to comply with the 10-year withdrawal requirement. And that class includes, of course, the surviving spouse of the deceased account owner. If there is a surviving child that has not reached the age of majority, that is 18, they will not have to comply with the requirement. Disabled individuals and chronically ill individuals within the meaning of the Internal Revenue Code. And lastly, individuals who are not more than 10 years younger than the deceased account owner. So the elimination of this whole stretch IRA concept is expected to generate $15.7 billion in additional taxes in the first year alone. Now, how are estate and financial planners counseling their clients about the stretch IRA elimination? Keep in mind, in the estate planning and retirement planning world, we frequently encourage the use of younger family members as the intended beneficiaries of IRAs. The idea is that these younger people would acquire the IRA at the death, typically of the parent, and they take the minimum distribution over their much longer lifetime. Since that's no longer possible, or if they don't meet one of those exceptions, they're going to have to take the distribution over 10 years, unraveling a lot of retirement and estate plans. So here are some of the top financial and estate planning strategies that financial planners and estate planners are discussing to try and deal with the elimination of the stretch IRA. Now, with income tax rates at relative historic lows until the end of 2025, many financial planners are recommending converting some of the traditional IRA to a Roth IRA. Now, a Roth IRA requires the taxes to be paid before the retirement account is funded, but then the distributions are generally tax-free. Some clients might benefit from paying the tax now and converting some of their traditional IRA to a Roth. Obviously, there'd have to be some assessment as to whether the intended beneficiary is likely to be in a higher or lower tax bracket than the owner who's converting the funds. The second planning option is to change some of the beneficiary or beneficiaries of the IRA. Typically, the spouse is named as the primary beneficiary upon the death of the first spouse. Now, in order to spread out the tax implications in the 10-year payout for non-spouse beneficiaries, the thought is to have some of those non-exempt beneficiaries receive some of the retirement plan benefits at the death of the first spouse. The idea is to distribute the taxable proceeds in steps with the hope that you'll reduce the income taxes over time. Again, there's going to have to be some analysis of the amount of the distribution and the likely tax brackets of the intended beneficiaries. And of course, for those who are charitably inclined, one could change some of the ultimate distribution to one or more charities and avoid payment of all of the income and estate taxes as well. Acquiring life insurance. It's long been an estate planning technique, Life insurance would pay to offset the income taxes that would be due on the distribution of the IRA over the 10-year period. And it's in essence a method of replacing the lost investment due to taxes. Lots of considerations here, including whether the client can even qualify for life insurance. As an estate planner, I've seen the rise and fall of life insurance as a planning technique in estate plans, particularly for addressing the federal estate taxes. As we know, the federal estate tax threshold has changed over time. The exemption has gone way up. My clients, in general, have been disappointed. They've had to pay so much in life insurance premiums to avoid the federal estate tax, only to see the exemption amount rise to now $11.5 million plus during their lifetime, making the purchase of life insurance unnecessary. The last planning option I'll mention is the use of a type of trust known as a charitable remainder trust. Now, trusts have been used in estate planning to deal with IRA distributions for some time. There is something called a conduit trust that requires all IRA distributions which are paid into the trust to pass out to the primary beneficiary. In the past, this type of trust enabled the primary beneficiary of the trust to utilize his or her life expectancy for stretch purposes. With the new rules under the Secure Act, this type of trust provides only an estate planning benefit for 10 years, after which the entire IRA is going to have to be paid out to the beneficiary. So if your client's estate plan had one of these trusts, you need to be aware of the estate planning limitations going forward. Normally, those estate plans were created for children or the beneficiaries where the parents did not want the kids to have direct access to their share of the inherited IRA out of fear that they would cash it out and spend it inappropriately. Now, for most estate planners, the trust technique that might still work for some of their clients is an older planning technique that had faded somewhat in light of the increased estate tax exemption, and that is the charitable remainder trust. A charitable remainder trust is a type of trust that attempts to replace the stretch concept of the IRA with a similar method of distributing a percentage of the trust over time to a beneficiary. It can be distributed over the lifetime of the beneficiary or for a term of 20 years. At the death of the beneficiary, the balance of the trust that remains passes on to a charity. Now, normally these trusts have been used for highly appreciated assets. I've done them for highly appreciated stock the client didn't want to liquidate due to capital gains tax that would have been due if they had liquidated it. Therefore, the stock was transferred to a charitable remainder trust. Then it was liquidated, free of the capital gains tax due to the charitable nature of the trust. Then the proceeds were reinvested, and my clients or their children received a lifetime income distribution from the trust. Now, the plan would essentially be the same with the use of an IRA. The charitable remainder trust would be funded at the death of both spouses with the balance that was in the IRA. The IRA would be liquidated free from taxes upon distribution to the charitable remainder trust. The proceeds would then be reinvested and distributed via an income stream to the lifetime beneficiary, presumably a child of the deceased IRA owner. At the death of the child, the proceeds would then pay to this designated charity. So in essence, you've created a new method of distributing the IRA proceeds over time to a beneficiary using a trust rather than an IRA. Charitable remainder trusts are complicated as there are IRS regulations that have to be complied with for them to work as intended. There are also different types of charitable remainder trusts, including those that make a fixed payment over time and those that recalculate the amount of the distributions on an annual basis. Final thought about the Secure Act. When the IRA rules were initially crafted, the IRA was not intended as a vehicle to pass on wealth to the next generation. The stretch IRA concept arose in the late 1990s due to an IRS ruling and then later pursuant to an IRS rule in 2001. Therefore, it was an add-on to the original IRA rules that we had at our disposal. With the Secure Act, the rules have been reset to a point in time over 20 years ago when IRAs were meant to serve as a tax-advantaged way to save for retirement, not necessarily for wealth transfer. right, the CARES Act was a response to the COVID-19 crisis and provided financial support for people and businesses. Part of the CARES Act addressed withdrawals from your IRA in 2020. First, there was a waiver of the required minimum distribution rules for retirement plans for 2020. This provision provides relief to individuals who would otherwise be required to withdraw funds from their retirement accounts. This also covers individuals who turned 70 and a half in 2019, but elected to defer their initial distribution to April 1st of 2020. If an individual has taken their required minimum distribution, they can redeposit it if 60 days has not elapsed since the date of the distribution. There are also hardship withdrawals from IRAs. The CARES Act has created the ability for individuals to withdraw up to $100,000 from retirement accounts without having to pay a 10% penalty if they're under 59 and a half. Now, to qualify for this relief, you need to fall into one of two categories. First, you, your spouse, or your dependent is diagnosed with COVID-19. Second, you've suffered some sort of financial consequence as a result of the pandemic. This might include reduced income from being quarantined or furloughed. Maybe your hours have been reduced. You're unable to work due to childcare issues or other issues beyond your control. It's a pretty broad category. The waiver of the 10% penalty is retroactive to January 1st of 2020. So if you had taken a distribution from your retirement plan earlier in the year, it will now qualify for this waiver. While the distribution will be still subject to taxes, as with any retirement account distributions, the tax liability can be spread out over 3 years. Additionally, you'll be able to recontribute the money back into the account over the next 3 years to avoid some or all of the taxes. These contributions can be made without regard to the normal plan contribution limits. The CARES Act also doubles the maximum amount that can be borrowed to the lesser of $100,000 or 100% of the participant's balance. These limits extend through the end of 2020. All right, let's go back in time to 1980, the dawn of a new decade of entertainment. The 70s were over. It was time for a new culture. The 80s were a decade of big stars and even bigger movies. Interestingly, the biggest movie of 1980 was a sequel to the biggest movie of the 1970s. And yes, it was Star Wars, The Empire Strikes Back. It was arguably the best film of the Star Wars series. It has spawned 11 films to date, including last year's rather disappointing The Rise of Skywalker. In The Empire Strikes Back, Yoda was introduced, Luke Skywalker learned he had some daddy issues, and Princess Leia fell for that scoundrel Han Solo. Other notable films of the decade included 2 vehicles for Saturday Night Live stars. The Bill Murray favorite Caddyshack, starring a very determined gopher, along with appearances by Ted Knight, Chevy Chase, and the legendary Rodney Dangerfield. There was also John Belushi and Dan Aykroyd in The Blues Brothers, where brothers Jake and Elwood were trying to raise money to save an orphanage. In the finale, they had the entire city of Chicago chasing them. Dolly Parton, Lily Tomlin, and Jane Fonda were working 9 to 5, with Dolly singing the hit title song. Robert De Niro and Martin Scorsese were still working together in the classic boxing flick, 8 Raging Bull. Back then, De Niro gained a lot of weight to play the troubled boxer Jake LaMotta. Working again with Scorsese in The Irishman, a film released last year on Netflix, they used computer technology to make De Niro appear as a much younger version of the mob hitman he portrays in that film. All right, I'm not going to go over each and every change to our various laws brought about by the COVID-19 crisis. However, I'm going to give you a sampling of some of the changes that have at least temporarily changed our practice in either estate planning or elder law. First, there's been an introduction of remote notarization into our practice that may outlast the pandemic. Remote notarization is when you do not need to be physically present when a notarization is made. In these cases, electronic communication is used to allow the notary to view a signing of a document. Under Act 15 of 2020, remote notarization is authorized for every type of record and transaction. Now, the temporary authorization will expire 60 days after termination of the COVID-19 disaster emergency that was issued by our government. The new provision initially requires the notary to notify the Department of State that the notary will be conducting remote notarizations and designate the technology that the notary will be using. There is an online form that has to be completed. There are no additional fees or training. Now, the technology that's going to be used has to satisfy certain requirements. First, the technology must enable a notary to communicate remotely with an individual simultaneously by sight and sound. The technology must allow the notary to determine the identity of the remotely based person, either based upon personal knowledge, the testimony of a credible witness, or acquiring identification. The technology must include a means by which the notary can identify the record that is being signed by that person in another location. So there's going to be an electronic signature system with tamper-evident technology that will be used. Lastly, the technology must create an audio-visual recording of the notarization, including all the interactions between the notary and the remotely located person. And that record has to be kept by the notary for 10 years. The Department of State will have a list of approved technology vendors. By the way, the common systems that we communicate with, such as Skype, Zoom, FaceTime, those are not going to be acceptable on their own. There are many electronic notary systems that are already used in business transactions, such as real estate closings. Two of the systems that are approved here in Pennsylvania are DocVerify and SafeDocs. Right, prior to passing of the Remote Notary Act, a separate order was issued by the Department of State authorizing the use of virtual notarization for wills, financial and healthcare powers of attorney, living wills, as well as standby and temporary guardianships. Now, although the technology is temporary in Pennsylvania, it does open the door for some opportunities for notaries to conduct business in our state. They haven't been able to do so in the past. It will also certainly create a host of issues that are not necessarily addressed by the law permitting virtual notarizations. For example, in the estate planning world, these issues include whether witnesses to a document need to be physically present. For example, there's no waiver in the law of the two-witness requirement for the signing of a last will and testament. They would presumably still need to be physically present and watch the testator sign. So many estate planning practitioners are concerned that the remote notarization alone is not going to help us in the signing of some estate planning documents, such as out-of-office signings, particularly at facilities. Now, in some cases, it will work just fine. For example, Marshall Park and Weber does have a satellite office in Wilkes-Barre. If I'm in Wilkes-Barre with the client and two witnesses, the notary can be present in Williamsport, so viewing the client sign via that virtual notary technology. Well, as with most state services, the Department of Revenue closed their offices in light of the COVID-19 crisis. The department issued some new directions for the filing of tax returns. They announced the deadline for taxpayers to file their 2019 Pennsylvania income tax returns is extended to July 15th of this year. This means that taxpayers have an additional 90 days from the original deadline. The Department of Revenue will also waive penalties and interest on 2019 personal income tax payments. The extension applies to both final 2019 tax returns and those payments and estimated payments for the first and second quarters of 2020. As for the Pennsylvania inheritance tax returns, the department did recognize that some taxpayers were going to be unable to meet their inheritance tax filing and payment obligations. So to address those concerns, the department asked the county register of wills to implement the following procedures. If a taxpayer is filing a return or making a payment that was due during the time frame the department was closed, the register is to stamp a date received as of March 12th, 2020. That was the date the office was in fact closed. In addition, the department will not apply penalties for payments received late that would otherwise have been timely during the closure. Now, we've been filing tax returns right along during the crisis. We have not seen a problem with getting confirmation of receipts from the local registers. In fact, probates are now starting to commence as time goes on during this crisis. Now, As for the stimulus checks issued under the CARES Act, they are not subject to Pennsylvania personal income tax. The payment is considered a rebate that is not taxable here in Pennsylvania. Now, if you're involved in a lot of tax issues, I suggest you visit the department's website where there is a long list of matters that are addressed for all types of taxes, appeals, and licenses. Now, there are also a lot of Medicare and Medicaid waivers issued by the federal government in light of COVID-19. There are just a few of them I think you might find relevant. Now, people covered by Medicare need to spend 3 nights in a hospital in order to qualify for skilled nursing care under Medicare Part A if they are then transferred to a nursing home. This has been an issue under the so-called observation status, where they're not actually admitted to the hospital, and therefore they don't qualify for Part A coverage of skilled care if they are transferred to a facility within 30 days. So there was a temporary rule issued by CMS that allows hospitals to discharge patients to a skilled nursing facility without the 3-day stay if they need to make room for COVID-19 patients. Now, this declaration also allows a provider to request more skilled care days than a Medicare patient is normally allowed. Typically, an individual can only get 100 skilled care days per benefit period. Under the declaration, the person will be able to request additional skilled care days without having to start a new benefit period. A directive was issued that makes it easier for people to retain their home health services if the order for those services happens to expire during the time frame covered by the emergency declaration period. Now, this is important for our older Medicare beneficiaries because most of them are staying at home in order to minimize exposure to the virus. The emergency declaration means they can get their home health orders renewed without having to see the doctor. The last temporary waiver deals with fair hearings. CMS allows enrollees to have an additional 120 days to request a fair hearing in an eligibility or fee-for-service appeal. Now, most of you know that the CARES Act provides a one-time direct payment of $1,200 to individuals earning less than $75,000 per year and couples earning $150,000 who file jointly. In addition, there are some individuals who earn a bit more who will receive smaller checks. Now, the basic Medicaid rule for nursing homes is that they must pay all of their income. Those nursing home residents must pay all of their income minus certain deductions to the nursing home. If the economic impact payment was considered income, it would likely have to go straight to the nursing home as part of the patient pay obligation. There was also a concern that since the Medicaid recipients can only have limited resources, the payment might put them over that resource limit. So the Department of Human Services, in line with some guidance from the Social Security Administration, issued the following. The portion of the economic payment that is spent within 12 months of receipt is considered an excluded resource for Medicaid eligibility. Any portion of the payment that's not spent within 12 months of receipt would be counted as a resource. Now, if the payment doesn't put you over the resource limit, obviously you can keep it all. Payment must be reported to the CAO, but it will be considered excluded income for Medicaid eligibility. In addition, the payment will not be counted as part of the patient payment obligation to the nursing home. Now, I'm hopeful this is the last time I'm going to have to mention community health choices as part of an elder law topic. As you know, these community health choices has been rolling out across the state for the last 3 years. Our region is part of phase 3, which is the last rollout phase. CHC affects older adults and persons with disabilities who are either dual eligible, that is, they're enrolled in both Medicare and Medicaid, or they're getting long-term care at home through an Office of Long-Term Living waiver, or they're in a nursing home where their care is being paid for by Medicaid. Now, what CHC changes is how these individuals get their Medicaid coverage. It's going from a fee-for-service plan that was managed by our government to a managed care plan through private insurance agencies. Now, the biggest news I can report on the transition in our area is that there's this ongoing dispute between Geisinger and UPMC. Specifically, UPMC has been unable to reach a provider contract with Geisinger Healthcare System. Geisinger is one of the largest providers in the Northeast. So if a contract cannot be reached, UPMC members who were already seeing a Geisinger provider prior to CHC will be able to continue to see them. Also, community health choice participants with Medicare as their primary insurance should be able to continue seeing their current Geisinger providers for Medicare covered services even if the Geisinger is not accepting UPMC. However, UPMC members who did not already have a relationship with Geisinger or they didn't have Medicare, they may be left with limited options within the UPMC network. Quite frankly, they'll probably have to change to one of the other two providers. Compared to phases 1 and 2, a larger percentage of phase 3 participants actively selected their CHC plan rather than just being auto-assigned into one of the three. Between 40 and 50% of phase 3 participants actively chose their CHC plan. Among the participants receiving home and community-based waiver services, the selection rate was even higher. And plan selection was particularly important for those groups, particularly the waiver recipients, because Medicaid was typically their only form of insurance, and they were at the highest risk of a disruption in their healthcare services since it was home and community-based care. Well, at the dawn of the 1980s, there was a disco hangover, and everybody wanted something new. What they got in 1980 was some of that 70s era feel-good music, and some of the older bands and artists were still hanging on for one last hurrah. When it came to the hit singles, Kulhanek were singing about that celebration that would last throughout the year. Blondie was a lot less punk when they had their big hit, The Tide is High. Remember Irene Cara? Her first big hit was from the movie version of Fame. I'm Gonna Live Forever. Remember my name, Fame. Queen were huge in America with Another One Bites the Dust. That was one of the first 45s I ever bought. I remember going to an old department store called Caldor, looking at the list of the top 100 hits and picking one of those out with my allowance. The 45s cost $1 back then. Millennials, you may want to ask your parents about 45s. What would become one of the biggest rock albums of all time, AC/DC's Back in Black, was released in 1980. I wore that cassette out. Those Hell's Bells scared the heck out of me when I first heard that song. Pink Floyd also released their most commercial album, along with the movie entitled The Wall. Remember Bob Geldof was playing the lead character in that movie. He went on to organize Live Aid. One of the lyrics from that album was, "We don't need no education. We don't need no thought control." Still very much a theme today with homebound children everywhere. Sorry, parents, you have my sympathy. Bob Seger and Billy Joel released classic albums with Against the Wind and Glass Houses. Bob Seger recently retired at age 74. At age 70, Billy Joel is not that far from behind. This was his rock album. He had hits like You May Be Right, Still Rock and Roll to Me, and Sometimes a Fantasy. A year later, MTV would launch a new wave of truly 80s recording artists that would eventually take over the decade. Beginning in April of last year, the Office of Long-Term Living launched the new Functional Eligibility Determination Process, which is used to determine clinical eligibility for home and community-based services along with nursing facility care. Previously, the assessors had used the level of care determination tool. Now, the Office of Long-Term Living will use this new FED process to determine and redetermine those who are nursing facility clinically eligible, also known as NFCE. A FED is a multi-step process that begins with an assessment and concludes with translating the scores to determine if the individual is NFCE. The independent assessment entity has contracted the local area agencies on aging to conduct the initial clinical assessments. Now, the reassessments are going to be conducted by the Community Health Choices managed care organizations. Now, the FED tool has 5 sections covering physical, behavioral, and functional attributes. They are cognition, mood and behavior, functional status, continence, and treatments and procedures. Now, the scores are given for each attribute within those categories by the assessor. The scores are then used to make the clinical determination. The assessor enters the scores into an automated program. The program translates the scores to determine if the individual is nursing facility clinically eligible. The assessor can comment on the findings, providing any information they feel is relevant to the determination. The physician also has to certify the NFCE determination. If the assessor or the physician disagrees with the outcome of the FED process, a department physician actually will come in and review all the available documentation and make a determination. Now, my initial experience with this new tool was to encounter one nursing home resident who failed the test. It was a shock to me, the family, and the facility. Of course, the FED tool is intended to limit some of the variables that would have otherwise permitted some people to achieve nursing home clinically eligible status under the prior system. So the consequence in my case, and probably in some others, is to force individuals who otherwise would have stayed in a nursing facility under the old review process to now seek care in another environment. Maybe it's a personal care home, or maybe there's some care they can achieve back home. In my case, the person had to enter a personal care facility rather than a nursing home. Now, a federal appeals court unanimously upheld a lower court's ruling that struck down work rules for Medicaid recipients in Arkansas, casting a lot more doubt over the Trump administration's efforts to require people to work, volunteer, or train for a job as a condition of getting Medicaid coverage. Now, the Arkansas work rule led to more than 18,000 people losing coverage before a district court blocked it in March, leading the Trump administration to appeal to the circuit court. The rule required able-bodied adults to report to the state each month that they have worked, searched, or trained for a job, taken classes, or even volunteered in order to keep their Medicaid. So the District of Columbia Court of Appeals found that the Arkansas work requirement was arbitrary and capricious because it didn't address how the program would promote the objective of Medicaid as defined under federal law, and that is to provide health coverage for those of limited means. To date, the Trump administration has allowed 10 states to condition Medicaid eligibility for many adults with proof that they work. Only Arkansas had put that work rule into effect. The appeals court ruling will likely influence other cases that will be heard in the same circuit. They could give further pause to states outside the circuit who are pursuing these work requirements. Many of the 7 other states that had such requirements, that is Arizona, Indiana, Michigan, Ohio, South Carolina, Utah, and Wisconsin, have voluntarily put them on hold while these court battles play out. Now, in the back and forth battle over the use of arbitration clauses in nursing home admissions agreements, the federal government has issued a final rule that limits their use. Now, the final rule was published on July 16th of last year by the Centers for Medicare and Medicaid Services. Now, when someone is admitted to a nursing facility, there's a lot of paperwork to be signed, along with the admissions contract and various information forms and authorizations. Most nursing facilities include an agreement that requires the resident to arbitrate disputes that may arise in the future. Now, an arbitration provides parties to a controversy with a choice other than litigation. Unlike litigation, arbitration takes place outside of court. The two sides select an impartial third party, typically known as an arbitrator. They agree in advance to comply with the arbitrator's award, and then they participate in a hearing in which both sides can present evidence and testimony. The arbitrator's decision is usually final, and courts rarely examine it. Now, in theory, arbitration has a lot of advantages over litigation. Proponents say arbitration is easier, it's cheaper, it's faster. Now, the critics argue that the price of efficiency is a lower quality of justice, and it can be made a lot worse by the difficulty of appealing an inappropriate award. Now, CMS's final rule allows long-term care facilities to continue to request that residents and their representatives agree to a binding arbitration. But there are also a few important safeguards that attempt to provide some measure of protection of the resident's right to make an informed decision to agree to the arbitration. The new rule requires that the facility explain the arbitration agreement to residents and their representatives. They are to advise them that they're not required to sign it, and that their admission to the facility is not contingent on their signing of the arbitration agreement. Now, the rule also specifies that the resident is given 30 days to rescind the agreement. That new rule took effect on September 16th of last year. Now, last year, CMS implemented a new Medicare payment reimbursement model for skilled nursing facilities. It is known as the patient-driven payment model. The model is described by CMS as a patient-driven care model that focuses on the diagnosis and characteristics of the patient rather than the services that they're being provided in the skilled nursing facility. As the system creates totally different financial incentives for skilled nursing facilities. For instance, facilities now receive a higher reimbursement rate for residents with more clinically complex needs, such as those who might be on ventilators or IV medications. Maybe they're severely cognitively impaired or they have depression. Under the new model, Medicare has a declining per day payment rate, which means that a facility is paid more on the first day of a patient's stay than on the last. And lengths of stay exceeding 15 days bring in lower rates. Now, there are concerns that this could result in the discharge of residents before they are physically ready to leave the facility. Now, to address the likely drop in revenue from Medicare coverage, many skilled nursing facilities across the country started to reduce some of their staff of therapists who were engaging in physical, occupational, and speech therapies. Now, the home health industry is also seeing an overhaul in their billing practices for Medicare. They have a new payment reimbursement model known as the patient-driven grouping one. Much like the facility model, the goal is to reimburse based upon the nature of the care rather than the amount of the care. Instead of paying home health agencies for each therapy visit, Medicare now pays based upon a complex calculation of the patient's need. In addition, Medicare now pays home health agencies for 30 days of care instead of the 60-day period. There are also new payment rules for home health care agencies that provide a small number of therapy visits for an individual patient. Now, one of the interesting changes in this system is that the new model includes higher rates for home health care patients after an inpatient institutional stay. That is, if they come home from being in a hospital or a skilled nursing facility, they get higher rates. And they get lower rates if they come from other environments, such as hospital outpatients, observation status from the hospital, including those people who start to get their care in their home. Those people are going to see a lower reimbursement rate for their care. The home health care industry's new billing system took effect on January 1st of 2020. And it was reported that many home health care agencies anticipated decreasing therapy utilization in 2020 because of this much more complicated reimbursement model. Now, federal watchdogs have frequently gone after providers that they accused of billing Medicare for unnecessary therapy visits. In general, CMS says it's changing in how therapy services are paid for, in not only the home health industry, but also skilled nursing facilities as a way to combat fraud, waste, and abuse, all while trying to put patients at the center of their care plans. Now, in light of these changes, there were reports that home health care agencies were incorrectly telling their patients that Medicare no longer covered therapy under the home health care benefit. So CMS issued an official response in February of 2020, addressing the concerns over the new payment model, stating that while the reimbursement system has changed, eligibility criteria and coverage for Medicare home health services remained unchanged. Well, let's go back to TV in 1980. I remember our family television set. Back then, there was no remote control. You had to get up out of your couch, walk to the set, and change the channel. I remember arguing with my sisters about whose turn it was to go change the channel. Your guide as to what was on was the TV guide from the Sunday paper, and you had to watch the show when it aired. There was no streaming of TV shows whenever you desired. If you missed a show, you better hope there was a rerun you could catch during the summer. And there were only 3 networks to choose from. For primetime viewing, there was CBS, NBC, and ABC. Cable was just starting out, and those of us in rural areas, well, we had to rely on an antenna mounted on your roof. I remember my father climbing up there and shouting down to me or my mother as to what the reception looked like on the TV. Big shows at that time included Dallas with the nefarious J.R. Ewing, played by Larry Hagner. There were lots of those primetime soap operas in the 1980s. Falcon Crest, Dynasty, and others. Who can forget MASH with Hawkeye, played by Alan Alda? My parents loved this show. It was Colonel Potter, Klinger, and others. The Love Boat. Love, exciting and new. Come aboard. We've been expecting you. Join Captain Stubing, Doc, Isaac, Gopher, and Julie for another episode with guest appearances from Ernest Borgnine and Charlo. The Dukes of Hazzard. Well, they were huge in 1980. Remember that Waylon Jennings theme song about the good old boys, Bo and Luke Duke, who were never meaning no harm? They went up against that mean old Boss Hogg and Sheriff Roscoe P. Coltrane. Two late great actors, John Ritter and Michael Landon. They were in hit TV shows in 1980, Three's Company and The Little House on the Prairie. Well, last year I reported on the inheritance tax bill that has now become law. Pennsylvania has eliminated inheritance tax on transfers from a parent to or for the use of a child aged 21 or younger upon the death of the parent. This includes transfers from a natural parent, an adoptive parent, or a step-parent. The inheritance tax rate on transfers from parent to child or other descendants is normally 4.5%. The new law reduces the tax rate to 0% on the transfers from the parent to the child if the child is under the age of 21. Now, this change mirrors a change in the law that was enacted several years ago, which set the rate of 0% on property transferred from a child 21 or younger to a parent. And it also follows other exemptions that I've reported over the years, including the family business exemption and the family farm exemption. New 0% tax rate applies to property transferred from a parent to a child who dies after December 31st of 2019. A new voting option takes effect for this year's primary election. Along with voting in person, it allows Pennsylvania registered voters to use a mail-in ballot. For those who are registered to vote by May 18th of 2020, you can apply for mail-in ballot. Your ballot must be received by May 26th by 5 p.m. unless a court changes that. There's currently a challenge going on. The new law does have a requirement to request the ballot 50 days before an election, but that has in fact been waived for the primary in light of COVID-19. If you have a valid PA driver's license or a PennDOT ID, you can apply online. If you don't have either one of those, you can download a paper application at votes.pa.gov and mail it to the county election office. You can still apply for an absentee ballot if you meet one of those lists of reasons that prevents you from going to the polling place. However, if you do not meet that criteria, you now have the option just to ask for one of these mail-in ballots. I report on this because the new system is so much more convenient for older adults who have a difficulty getting out to vote in person at the polling place. So everybody in every assisted living or other facility should know that their residents can in fact get one of these mail-in ballots for their residents. This no excuse mail-in option is in line for 31 other states that have similar systems in place already. Well, since we've been looking back 40 years, I thought it would be appropriate to look forward 40 years and think about what estate planning might look like in the year 2060. I will hopefully be retired by then, but maybe my successor will be around to carry on the work of Marshall, Parker, and Weber. Some of the changes that I can confidently say will be part of our world have come about by the impact of COVID-19. I already talked about one of them, the introduction of electronic notarization here in Pennsylvania. I don't think this is going to be a temporary change. Perhaps the law as written will be changed slightly, but I'm confident that electronic notarization is here to stay. And that opens a door to the world of electronic estate planning. Another sign that digital technology is going to affect our estate planning practice is the Pennsylvania Senate's unanimous passing of Senate Bill 320. The bill grants Pennsylvanians the ability to plan for and manage for the disposition of digital assets in the same way that we can transfer personal physical property. That is by providing instructions in a will, trust, or a power of attorney. Proposed legislation will codify the Uniform Digital Assets Act, which has been adopted in 46 other states. So instead of being lost forever in the digital cloud, a deceased person's digitally stored items such as books, music, videos, photos, and documents, they can now be transferred to their beneficiaries. So in light of this, I believe our electronic and digital world will soon render paper estate planning documents unnecessary. Think of where we are right now. Does anybody really need an original healthcare power of attorney? How about a financial power of attorney, an original one? A trust? I think only original wills still have the respect due a truly original document. And yet, if these electronic technologies allow for the proper execution, notarization, and even witnessing of an estate planning document, could we soon see a time when we can create an original electronic will, along with all of the other estate planning documents? Sure, maybe there'd have to be some sort of seal or certificate that the electronic file is authentic, but it meets all of the standards for execution. How can it not be honored as much as a paper version of the same document. So I don't think it will take 40 years for us to see this electronic and digital world of estate planning. The Uniform Law Commission recently approved the Electronic Wills Act. Many states are moving to adopt a digital estate planning process. Nevada, Indiana, Arizona, and Florida have passed laws authorizing electronic wills, or for short, e-wills. California, the District of Columbia, New Hampshire, Texas, and Virginia are also considering similar legislation. Now, some of the benefits of electronic estate planning include the requirement that the execution of the documents be videotaped. Now, that's an element that doesn't exist with paper wills, and many may reduce some of the claims that the testator did not have the capacity when the document was signed, or perhaps was unduly influenced to sign the will. In addition, the location and security of the documents would be enhanced by having an electronic file. In many cases, our older adults just misplace their estate planning documents, and the children can't find them when they need them. With a digital file, it can always be accessed in the cloud. So perhaps I will be around to see the day when I don't meet with my clients in the office. I see them via the Zoom technology of the time. I will create the documents with dictation software, as typing will no longer be needed. I'll have the clients sign them with virtual software that allows us to execute the documents electronically. And the clients will receive a digital file that's saved in the cloud server of their choice. I think that future is fairly realistic, not just for the estate planning world, but for a lot of other professions. Well, 40 years ago, Jeff Marshall had a vision to create an elder law firm that would help older adults get the services they needed for long-term care and to find a way to pay for it. He successfully accomplished that vision, and the firm is now in its second generation. I want to thank all of you who have supported the firm over these years. As you know, it's a tough time out there for a lot of people. I think more than ever, we're all going to need each other. Marshall Parker and Weber will be there for our clients and our fellow elder care providers. So stay safe and healthy, and we will see you again next year.